It's great to welcome Jessica Pieklo back to the program. She is a senior legal analyst for Rewire, which is a daily online publication covering reproductive justice. Today, we are going to talk about Masterpiece Cakeshop v. Colorado Civil Rights Commission, which might be known to you as the gay wedding cake case, which is now before the Supreme Court. So, Jessica, as with many of these types of cases, we can't even seem to get agreement from two sides, at least, about what the case is about. There are some who say this is about anti-LGBT discrimination, and others who say that it is a case about religious freedom. So for people who don't know even the facts of the case, what is this about?
Sure. So I'll give you guys a quick rundown of the facts. So there's same-sex couple who walked into Masterpiece Cake Shop. They were looking for a cake to celebrate their wedding, and they had been married in Massachusetts and were a Colorado couple, and so wanted to celebrate in Colorado. And Phillips, who's the owner of the cake shop, refused to sell them a cake once he realized basically who they were and what they wanted. And he said, I won't sell a cake to you. I won't make a cake to you because I have a religious objection to same-sex marriage. The couple filed a complaint with the Colorado Commission of Human Rights. The commission did an investigation and found that the refusal to serve the couple was in violation with Colorado's anti-discrimination statute. And Colorado, like a lot of other states, has an anti-discrimination statute that says effectively you cannot discriminate against folks on all of the usual characteristics that we have in civil rights law. So that would be, race, national origin, age. But the Colorado civil rights law, as do many of the states, goes further and specifically includes sexual orientation. And so the commission very rightly said this is a problem. Phillips appealed, and the Court of Appeals said it, reaffirmed the commission's decision. And then Alliance Defending Freedom, who represents Phillips and their conservative litigation group, they filed a brief with the Supreme Court. The Supreme Court sat on the case 19 times before taking it up. So that in and of itself is very interesting. So that's Phillips' side. The commission side, and has been argued by the folks who have filed amici on behalf of the couple, detail the very long history that this country has of religious evangelicals in particular trying to launch religious objections to civil rights laws. The Supreme Court has already looked at this as an issue in the case of Bob Jones v. the United States, where Bob Jones University tried to defend its decision to not allow housing for interracial couples on the grounds that it had a biblical objection to that. And the United States Supreme Court said it was fine for the government to pull its nonprofit tax funding status in that case. So this should be a no-brainer. The fact that it is not is something that advocates should pay attention to.
So there is an argument that some defenders of the cake baker are making, which is that this is not equivalent to we do not serve gay people in our business. They are saying they have the option to participate or not in the baking of cakes for gay weddings, which are a type of event, and that they are not actually refusing service to the couple on the basis of their identity, that they're refusing service on the basis that it's a type of event for which they don't work. Is that legally a valid distinction or argument?
Well, I think it's a pretty facetious argument. And I mean, I will, anecdotes aren't evidence, but I will just say, for example, that when I got married, I hired a bakery to bake our wedding cake. And in no way, shape, or form did they participate in the ceremony or in any way do anything that suggested they were endorsing the union that I was entering into. The folks who are defending the baker, and Phillips has made this argument as well, are trying to say that he's an artist and what he's doing is purely expressive speech. And as Justice Sonia Sotomayor pointed out in oral arguments, well, there are people who consider themselves sandwich artists. Does that mean if you have Subway cater your student event that they are somehow endorsing the message of it? It's really, I mean, when you start to drill down into it, ludicrous.
What about the idea, and I'm just thinking out loud here. I mean, I happen to think that that the baker is wrong here, right? But in the interest of playing devil's advocate and really thinking it through, I was imagining a scenario where a heterosexual couple, right? Maybe it's someone related to one of the two men who were going to get married, if they were to come in and say
Mm-hmm.
that they were buying a cake for the gay wedding, and they were, of course, a heterosexual couple, and the
Mm-hmm.
individual baker said, I don't do cakes for gay weddings, for example, would that be
Mm-hmm.
different? Because again, it's not the couple that they're refusing to provide something for that's coming in to place the order would be a heterosexual couple, but the eventual use of the cake would be in a gay wedding. Does that example support the baker's argument in some way?
It's a really excellent hypothetical, and I'm glad you asked it because what it allows us to do is really talk about, the who or versus the what is how I like to describe this case, right? Is it an objection to who or to what? And your example flips that because you're absolutely right. It's not the baker launching an objection against the person, but refusing to participate in a ceremony. If they were fine like giving the heterosexual couple or the heterosexual person the cake on their behalf, it immediately undercuts their argument because it is absolutely then about who they are comfortable about serving. They claim it's about the what, but I'm not sure if that distinction, it's slicing the apple kind of thin, but in my mind that actually helps the couple's case
Hmm.
because in that sense, because if they agree to serve a heterosexual person or a heterosexual couple, regardless of what the event is, and even if it's an event that they say they object to, then they're not participating in that event with any, real, it undercuts their participation argument.
I was
And
actually
it
thinking of the opposite, which is if they said, even to
interesting.
the heterosexual couple, we don't do
Oh,
cakes
okay.
for gay weddings. And that would actually, in some sense, strengthen their argument. In either case, we're talking about hypotheticals, though.
Sure, sure, sure. I mean, I certainly think that is a more compelling point to the baker's side because it is again this idea of objecting to or putting forward that objection, but it doesn't change the end result that what they are objecting to is something that is a legal right and that is a legal right held by a traditionally discriminated against class of people. So you can dress it up in different ways, but in terms of the outcome, it is still saying, I have a religious objection to a constitutional right that you have. And historically, the law has just not recognized that, and with good reason.
Yeah, so that's kind of the bigger picture here, which is with a lot of these types of legal debates, you have a sort of butting heads of freedom from and freedom to, in the sense that the Colorado non-discrimination law, by including sexual orientation as a protected class, says that individuals who are part of that, members of that class, should be free from discrimination. And
Mhm.
those on the other side say that our religious freedom gives us freedom to sort of exist in society in accordance with our religious laws. Isn't that really what's at issue here?
It is, except I would take that further because the balance that you describe is absolutely an important one and one that traditionally has not been an issue aside from what the evangelicals have pushed. Because it is possible to recognize a myriad of religious beliefs and also recognize the fundamental civil rights of people in this country. So I think there's that part of it. And then in terms of really the larger piece, I would say that this is an example, and it's been increasing really since 2010. It's sort of gone on hyperspeed under the Trump administration of evangelicals trying to use religious objections and, quite frankly, weaponize the First Amendment as both a sword to puncture through civil rights laws and a shield from the liability that happens when they do so. I mean, frankly, we saw this setup with Hobby Lobby. They have great opening to do so now.
Yeah, that was, I mean, when the Supreme Court decided that state bans on same-sex marriage were not going to fly, it was abundantly clear at that point, and the Hobby Lobby case was one of the big notable examples, that the shift in the battle against LGBT rights was
Hmm.
going to move to religious freedom. And still, by the way, I mention this anytime that there's an opportunity to. I don't remember the number of states, but in many states, you can still be fired for your perceived or actual membership identification as an LGBT
Hmm.
individual, and that is a completely separate issue from that of same-sex marriage. And I don't know if you have thoughts about where that's going.
Oh, absolutely. The Supreme Court just this week refused to hear a case on that exact issue. There's currently what we call in the law a circuit split. So federal courts of appeals are not in agreement as to whether or not firing someone from the workplace because they are gay amounts to discrimination on the basis of sex under Title VII of the Civil Rights Act, which is the federal employment law. So that is very much an open question for debate. Now, I mean, it's always reading the tea leaves in terms of why the Supreme Court decides to take up a case and why they don't. I wrote a quick piece on this in terms of why this particular case that they considered may not have been a really good candidate, but this is absolutely an issue we are going to see because exactly what you mentioned. In many states, it's still possible to lose your job because you're gay. And there is, or it goes even further in terms of like certain gender nonconforming behaviors and stereotypes. So, that in addition to the fight over how the law recognizes the rights of transgender people too is really the burgeoning civil rights battle that we are seeing right now.
Last thing to touch on, as far as this case goes that we started today's discussion about, when might we expect to hear a decision, and what ultimately will the decision hinge on in your mind?
Okay, so the court was positively packed with press to the point where we were given assigned seats. So this is likely the biggest case, or certainly one of the biggest cases on the court's term. So that usually means an end of June decision. Particularly since they conferenced on it so long, I think this is going to be one to hash out. I would like to see it earlier in the sense that I would be hopeful that it's an easy question for the court to answer. In terms of what it hinges on, as we have seen time and time again, a lot of the outcome of this case hinges on Justice Anthony Kennedy. He has two real competing legacies here. He has his legacy of advancing LGBTQ rights, even if it has been slowly, but that's how the law works, and really working to insulate religious individuals and in particular religious conservatives to he's the Hobby Lobby decision to allow them space to exist in civil rights laws that they did not have the space to exist before, and with good reason. And so we'll see where he comes out in this case. He was very concerned about using civil rights laws to discriminate against the LGBTQ population. He was as concerned that ruling against the baker would somehow endorse what was argued by the baker as religious discrimination by the state against evangelicals. So it's going to be a close case. I would expect a pretty split along ideological lines decision.
All right, we will be following it. We've been speaking with Jessica Pieklo, Senior Legal Analyst for Rewire. Great to talk to you again.
Thank you so much for having me back. Always such a pleasure.